Okay, time for some equal protection. Now that we've talked about substantive due process, including the abortion right, we turn to equal protection. So here is our checklist for your review to make sure that every item right on this list is something that you understand thoroughly. And as I've been saying in these videos, if you do understand everything on this slide thoroughly, you're good to go on equal protection. If you don't, you need to bone up on it. So, as far as your equal protection checklist, first of all, you need to obviously know your suspect classes and your quasi-suspect classes, right? Race, ethnicity, alienage, and sometimes religion, right, are suspect classes. I say sometimes religion because courts often deal with religion under the First Amendment, as you know, rather than the Equal Protection Clause, but occasionally courts throw that out there. Gender and people born out of wedlock, right, would be your quasi-suspect classes. Everything else as of now is a non-suspect class, which gets rational basis review. So obviously you need to know that, right? What are your suspect classes, right? So that you can go straight to strict scrutiny on those. What are your quasi-suspect classes, so you can go straight to the appropriate level of scrutiny, and what are your non-suspect classes? You also need to know, secondly, right on this slide, assuming that the class that you're looking at in front of you, right, is not a suspect class, the next question is, should it be? And that's where you need to know your factors, right? Your factors for whether a classification is suspect, right, would be immutable characteristic, history of political powerlessness. You need to be able to distinguish between that, right, and politically unpopular, right? Politically powerless is one thing, politically unpopular is another, right? So we're talking here about a history of political powerlessness as one of the factors, right, for people being targeted and losing all the time, right, as one of the factors for whether it's a suspect class. And finally, the issue, in some cases, the court discusses, right, whether the characteristic that's being targeted has anything to do with the person's ability to contribute in some way. Okay, so you apply those factors and you decide whether the class should be suspect. Now, obviously, as in of constitutional law, you must have mastered your levels or standards of review, right? And we use those terms interchangeably. Level of scrutiny, right? Level of review, standard of review, right? Those terms all mean the same thing. And here I've got kind of 5 of them that, once again, if you really understand equal protection, you're okay with all this, right? You've got strict scrutiny, you know, the burden of persuasion and how that works. You've got intermediate scrutiny plus, right? Which I'm using that as shorthand for what courts apply to the gender cases, right? Run one more time on a bar exam, you go straight for intermediate scrutiny, right? Substantially related to an important interest. But certainly if you were to see, in real life or in my exam, if you were to see a gender discrimination issue, it would be appropriate to say that in a couple of cases, Mississippi University for Women and the VMI case, right, the court said that the means would at least have to be substantially related to an interest that is exceedingly persuasive. So that's why I have that, right, IS plus. Then you have your regular intermediate scrutiny, which I just described, substantially related to an important interest, which still has teeth, right, but it's a little, it's a little lesser than strict scrutiny. And then you want to be familiar with your sort of two forms of rational basis, right, when it comes to an equal protection case, right, and this is not something you see in the due process cases. In equal protection cases, courts either apply Lee-optical rational basis, that's the bottom one, right, RB, or they apply what the commentators call rational basis with a bite, or rational basis with teeth, right, which I describe as a burden shifting. And RBB, rational basis with a bite, right, is a level of scrutiny that's triggered, right, that's a little more than, well, it's a lot more actually than Lee-optical rational basis. When the court sees animus, right, and animus is defined either as a bare desire to harm a politically unpopular group, thus my admonition earlier, you need to know the difference between politically powerless and politically unpopular, right? This level of scrutiny, rational basis with a bite, it doesn't have to be a politically powerless group that's been historically targeted. It just has to be a politically unpopular group that's being targeted now, right, for bad purposes. So that's one definition of animus. The other definition, right, is irrational fear. So you need to look, and that's the one the court applied in Claiborne versus Claiborne. So you need to be aware of all those, right, levels of review. Again, on a bar exam, there's only 3 choices, right, because the bar exam doesn't test intermediate scrutiny plus, and they don't test rational basis with a bite, right? They want to see strict scrutiny if it's a suspect class, intermediate scrutiny if it's a quasi-suspect class, rational basis review if it is a non-suspect class. Now, as to one of those suspect classes, ethnicity, one of the most tested topics on the bar exam is affirmative action, right? So you need to know your affirmative action grid. My sense is that most students are pretty comfortable with that. You've got to figure out what kind of case you're talking about. Is it higher ed or is it employment? If it's a higher ed case and you have your actual handout grid with you, if it's higher ed, right, you're looking for you're arguing that the compelling interest is diversity in higher education, right? And then as to the means, who are you talking to? Who are you talking to? Okay. All right. Back to work. Diversity is the interest. As to the means, it's right trying to achieve critical mass, right? Because you can't use numbers, and to do that, you treat somebody's ethnic status as a mere plus, right? When you're evaluating roughly equivalent, right, applications in an individualized way. So that's the higher ed side. On the employment side, you're looking at
remedying a history of past discrimination as a passive participant in that history.
As your interest. And again, we borrow from the education cases, right? You want, to the extent possible, you want to avoid numbers, right, in terms of the means, and look at somebody's ethnicity as a mere plus, right, in terms of competing applications for whatever, a bid or employment. Next up on our list, right, of things you want to understand very well in an equal protection, right, under the Equal Protection Clause, is your as-applied attack, right? Because again, there are plenty of fact patterns where you're going to see that on its face, a law or policy seems to target a group that is not a suspect or quasi-suspect class, right? But you see statistics in the fact pattern that indicate that a quasi-suspect or a suspect class actually is burdened under the law or policy. Now, when you see that kind of statistical evidence of some burden on a suspect or quasi-suspect class, then you need to look for evidence of intent, right? Because if you have disparate impact on a suspect or quasi-suspect class, remember, you would not do this for a non-suspect class, right? Because that gets you back to rational basis review. The whole idea of doing an as-applied attack is to try to get a court to bump up the standard of review that applies to the group that's really being targeted. And if the group that's really being targeted is a non-suspect class, that only gets you right back to rational basis review. So the elements, right, of an as-applied attack are a disparate impact on a protected class, right, and intent to target that group. I'm not going to rehash our entire discussion about proving intent in an as-applied attack under the Equal Protection Clause, but you know what to look for, right? The historical background, departures from normal procedures, right? Things like that the court says it wants to look, right, wants to see. But you know, when you see again, statistics of an impact, right, on a protected group under the Equal Protection Clause, you need to mine the fact pattern for any evidence of what the policymaker, the lawmaker, was up to, right? What evidence do you see in the fact pattern of what they were doing? Finally, voting. Voting, you don't worry about whether it's a suspect class or a quasi-suspect class, right? The strict scrutiny applies to any substantial interference, right, on the right to vote. Even Kramer, you remember Kramer, our friend Kramer. So keep voting in mind as well, the general principle, one person, one vote, right? And so even a class of one under the Equal Protection Clause will get strict scrutiny, right, with the exception of felons, which, that's a separate matter. But okay, so this is sort of your checklist of items, right? Once again, that if you understand these, you're good to go in equal protection. Don't forget the textual stuff, right? The 14th Amendment applies to states and subdivisions of states on its face. The Equal Protection Clause applies to the federal government through the Due Process Clause of the Fifth Amendment. And so once again, if you've got all that, you're good to go. So we'll be back with more, but we're making progress here. So be well, stay safe, and stay tuned.
Are you barking at me? Huh? What are you doing? Who do you think you are? Who do you think you are barking at me? Oh.